Hi guys, welcome back. Today our topic is citizenship under the constitution. The part 2 of our constitution discuss the citizenship which lies in the articles between article 5 to 11. So we will see one by one. On the commencement of the constitution on 26 January 1950, we had to know like who are the citizens of India. So the parliament come up with this. So the Article 5, citizenship by domicile. Article 6, migrants from Pakistan. Article 7, migrants to Pakistan. And Article 8, Indians abroad. Article 9, voluntary foreign citizenship. Article 10, continuance. Article 11, parliament's power. Okay. Citizenship defines the legal relationship between an individual and the state. It determines the political rights, civil rights, and eligibility for the public offices. So remember, the fundamental rights are available to both citizens and non-citizens in many cases, but certain rights are exclusively for citizens. Example, Article 15, Article 16, and Article 19. This one we will discuss later in this chapter. Okay. So when the constitution came into force on 26 January 1950, India has undergone a partition. The mass migration happened, so the constitution had to clarify who is a citizen of India on day one. So that is why the Article 5 to Article 11 exist. Okay. So we will see the Article 5 to Article 11 one by one, and then we will discuss in detail about the whole citizenship from how to get citizenship, how the citizenship can be removed, OCA card holders, and everything. Okay. Now Article 5. Citizenship by domicile. Article 5 says a person is a citizen if he had a domicile in India and either born in India or either parent born in India or ordinary resident for 5 years before commencement. So the domiciles means the permanent resident uh, with intention to stay in India. Okay. So either born in India, either parent born in India or ordinary resident for 5 years. Okay. So one parent must be from the India. He should have a citizenship of India, he or her. Okay. Next, Article 6. Migrants from Pakistan. This deals with people who migrated from Pakistan to India. It has two categories. The people who migrated before the 19th July 1948, who are automatically they will be citizens, and the people who have migrated after 19th July 1948, they must register. Why date is important? Because the permit system started after that. Next, Article 7, the migrants to Pakistan. This is a reverse migration. The people who went to Pakistan after March 1st, 1947 lost the Indian citizenship. However, if they returned under the permit for resettlement, they could regain citizenship. This shows the constitutional response to the partition. Okay. Next, Article 8. Article 8 talks about the Indians abroad, the persons of Indian origin residing outside India. They could register as citizens through Indian diplomatic representatives. Okay, this connects to the whole diaspora. Next, Article 9, voluntary acquisition of foreign citizenship. This leads to the loss of Indian citizenship. Important point is Indian does not allow the dual citizenship. Okay, if anyone voluntarily acquires another citizenship, they will lose the Indian citizenship. Next, Article 10. Persons recognized as citizens under Articles 5 to 8 continues as citizens subject to the laws made by the Parliament. Okay. If the Parliament can alter the rules from the Article 5 to 8. Next, Article 11. This is the most important topic. The Parliament has power to regulate citizenship by law. Based on this, Parliament enacted the Citizenship Act of 1955. All modern issues Citizenship Amendment Act, OCA, etc., come under this act. It is not directly under the Part 2. The CAA and OCA in all this Citizenship Act will come under the Article 11 of the Constitution. Okay. Next, we will see the basic constitutional features of the citizenship we will discuss. It has a single citizenship, unlike USA. India has no dual citizenship, and parliamentary supremacy in citizenship because constitution gives framework, but parliament controls the details. This gives the flexibility, and no dual citizenship. Through OCI exists, but it is not a full citizenship. This only overseas registration facility. Okay, they have some restrictions also. This one we will discuss in the end. Now our next topic is methodology of getting citizenship. We'll see how we can get the citizenship. The citizenship can be acquired by the following means: by birth, by descent, by registration, by naturalization, and by incorporation of the territory. We will see one by one. Okay. The Article 11 gave the Parliament powers to regulate citizenship under the Citizenship Act of 1955. First, we will see citizenship by birth. Okay. The rules have changed over time. We will discuss first in each phase. First, 1950 to 1st July 1987, the anyone born in India is a citizen. In the second phase is 1st July, from 1st July 1987 to 3rd December 2004, at least one parent must be the Indian citizen. And next, after 3rd December 2004, child is a citizen only if the both parents are citizens, or one parent is citizen and other is not an illegal migrant. This shows the tightening of the law. Next, we will see citizenship by descent. This is for the persons born outside the India. Again, this is also date based. Before 1992, a father must be Indian citizen, and after 1992, either parent, mother or father, can be Indian citizen. Also, the birth must be registered at the Indian consulate. Next, citizenship by registration. For certain categories of persons of Indian origin, this citizenship by registration is applicable. Examples: the person of Indian origin residing in India for 7 years, or he has a spouse of Indian citizen, and sorry, he is the spouse of Indian citizen, or like minor children of any Indian citizens. This is less strict than the naturalization. Next, citizenship by naturalization. This is for foreigners who are not of Indian origin. Conditions include they should reside in India for 12 years, and they should have a good character and knowledge of any one Indian language, and they should have the intention to reside in India. The government may relax conditions in special cases, like the people who did exceptionally well in any of their fields, like Mother Teresa, those kind of people. Next is citizenship by incorporation of territory. When new territory becomes a part of India, the government decides citizenship for residents. Example: when Goa becomes a part of India and Sikkim becomes part of India, the people will, the government, the parliament will decide the citizenship. Next, we will discuss what are the grounds to lose Indian citizenship. Okay. Modes of losing the citizenship of India. First one, renunciation. Next, termination. And third one is deprivation. Okay. We will see one by one. Renunciation is like voluntary surrender by citizen. Let's say if someone don't want to be a citizen of India, they can voluntarily renounce the citizenship of India. If the person, like a adult parent, renounces the citizenship, automatically the minor child also lose the citizenship. If the child becomes major, they want to resume, they can resume. Next, by termination. Termination is automatic loss of citizenship. If Indian citizen voluntarily acquires citizenship of another country, the Indian citizenship automatically ends. No government order required because India does not allow dual citizenship. Next, by deprivation. This is compulsory removal of citizenship by the government. It applies mainly to registration in citizens, naturalized citizens. The grounds includes citizenship obtained by fraud, disloyalty to the constitution, trading with the enemy during war, imprisonment within 5 years of registration, residing abroad continuously for 7 years. So the distinction between these three is renunciation is voluntary, and termination is automatic, and the deprivation is through the government action. Okay. The citizenship is a legal bond. If loyalty shifts or fraud is involved, the state can withdraw that bond. Okay. And we should also observe that the OCA is not a citizenship. So losing the citizenship does not mean losing OCA necessarily. They are separate legal categories. Next, we will discuss the citizenship provisions of Jammu and Kashmir. Okay, Jammu and Kashmir had a special constitutional position before 2019. To understand the citizenship provisions, then we must understand what is the Article 370. It has two phases. One is before 2019. Under Article 370, Jammu and Kashmir had a special autonomy. Indian Constitution applied partially in Jammu and Kashmir. What Article 35 says is like this inserted through the presidential order in 1954. It empowered Jammu and Kashmir legislature to define as a permanent residents of the state. Okay. Now the important distinction is they are not a separate citizens of India. They were Indian citizens, but with additional state-based privileges. Okay. They are not separate citizens, but they have additional state-based privileges. So, what are the permanent resident privileges? If we can see, only the permanent residents could own land in Jammu and Kashmir, and they can only the Jammu and Kashmiris can get government jobs. Only they can access the scholarships there, and only they can acquire immovable property there. And other Indian citizens could not enjoy these rights. This created a kind of limited internal differentiation. So even before 2019, there was no dual citizenship. People of JNK were Indian citizens, but they had a additional classification called like permanent resident status. This was unique within India. Okay. Next, we will see after 2019. In August 2019, the Article 370 was effectively abrogated, and Article 35A was removed, and Jammu and Kashmir was reorganized into Union Territory of Jammu and Kashmir and Union Territory of Ladakh. Now, the Indian Constitution fully applies. The permanent resident concept was removed, and new domicile rules were introduced by the central government. Now, citizens from other states also can purchase property and apply for certain jobs and settle in the region also, with subject to the certain rules. Okay. Before, so if we can observe here, before 2019, Jammu and Kashmir had a asymmetrical federalism, and after 2019, it has a full constitutional integration. Okay. Next, we will discuss the special privileges and enjoyed by the citizens of India. Okay. If you have Indian citizenship, what are the privileges that we will enjoy? So there are certain fundamental rights that are applicable only for the citizens of India. One is Article 15, Article 16, Article 19, and Article 21 Clause A and Article 30. And second one is the political rights. Only citizens can vote in elections, contest elections, and become MP or MLA. And next third one, eligibility for constitutional offices. Only citizens can become president, vice president, governor, judge of Supreme Court, and judge of High Court and attorney general. Attorney General. Okay. We'll see the article, all articles one by one. The Article 15 is a prohibition of discrimination of religion on grounds of caste, religion, sex, and place of birth. And Article 16 reads equality in public employment, and Article 19 freedom of speech, expression, assembly, association, movement, and residence and profession. And Article 29, Clause 1 is protection of interest of minorities. And Article 30 is right of minorities to establish educational institutions. Okay. So the Article 15, 16, 19, 29, and 30 are the citizen articles. And next we will discuss the OCI. OCI stands for Overseas Citizen of India, and PIO also. PIO is person of Indian origin. Okay. So first we will see who is an OCI. OCI stands for Overseas Citizen of India. It was introduced through Amendment of Citizenship Act 1955 and 2005. The purpose of this is to provide certain benefits to people of Indian origin who have taken the foreign citizenship. It is mainly aimed at the Indian diaspora. Okay, and who can become an OCI? Any foreign national is eligible if they were a citizen of India on or after 26 January 1950, or they were eligible to become a citizen at that time, or their children or grandchildren of such persons. So the citizens of Pakistan and Bangladesh are excluded from this provision. Benefits of the OCI. Next we will see. The OCA cardholders get lifelong multiple entry visa, and they don't need to register with the police for the long stays in India. And the party with the NRIs in economic, financial, and education matters also. And also very important, they do not get any political rights. We'll see what are the restrictions on the OCA card holders. The OCI card holders cannot vote, they cannot contest elections, they cannot become MP or MLA, they cannot hold any constitutional post, they cannot buy agricultural land. So OCI is not a citizenship, it is a special immigration status. Okay. So next we will see what is a PIO, person of Indian origin. So what was PIO? PIO means person of Indian origin. It was introduced in 1999. The PIO card holders had a visa-free travel, limited period to India, and they have some economic benefits as well. But it had limitations compared to the OCI. Okay, and in 2015, the PIO and OCI both are merged. Now PIO card holders are treated as OCI card holders. Okay, PIO does not exist now. Please subscribe if you want to see more videos like this. Thank you for watching. Bye bye.